Sister Rose. So this is another update in the Sakiyna Thompson court case. Yes, it's supposed to be over because she was found guilty of first degree. Yes, of course, the jury did their job. However, people have the right to request another trial, and that's what her lawyers did. They motioned for a new trial on these bases. Let's get into this foolishness. So this case went to trial on September 22nd, and it ended October 14th, where it ended in a guilty verdict. Now, she hasn't been sentenced yet, so she's supposed to be sentenced. But before that, they are motioning for a new trial. Interesting. But of course, she has the right to do that because we can't, she has the right to do that. Don't know why they're doing that, but because. Anyway, let's get into these reasons. Down here, it says Ms. Thompson is requesting that the court grant her motion for a new trial on the following grounds. The trial court erred, that means they made an error, in overruling multiple defense objections. So every time the defense will try to object to certain things that were happening in the court, I guess the the judge overruled it, and they felt like the judge probably wasn't supposed to overrule those objections. That's what I gather. The trial court erred in not conducting a Richardson hearing. What is a Richardson hearing? So I'm going to put it on this trial, but I'm reading from another phone. It says that the purpose of a Richardson trial is to determine whether there has been a violation of the discovery rules, and if so, to determine an appropriate remedy. So I guess they feel like certain things, the discovery phase of a criminal case, both the state and the defense have an obligation to disclose relevant information and evidence to each other. So they're sharing different things that they're gonna present, in trial, so nobody get blindsided. I believe, so the defense, the defense felt, the defense felt that I guess there was some certain things that were withheld from them, is what I'm gathering. That's what because they mentioned the trial court erred in not conducting a Richardson trial upon defense objection and request for a Richardson. They requested a Richardson trial. Okay, whatever. Anyway, so they felt that certain stuff the prosecution did not share with them, or maybe they were not transparent enough. So let's go on. Say request for a Richardson trial on testimony given by Detective Chris Williams and Detective Miguel Suarez. Both detectives gave opinions which are impermissible unless they are determined to be experts first. So I guess for them, they were supposed to be determined to be expert. They were just given their account, but they're just trying to pick at straws. I guess that's what they call it. Pick at straws. Okay. State did not list either of these witnesses as experts and did not qualify them as experts in court. So since they didn't qualify as experts, so their opinion shouldn't have care. I guess their opinion, well, to them, the defense, I guess their opinion or their account to me shouldn't have carried so much weight. I guess they felt that it carried so much weight, and that's what maybe they felt that convicted Sakiyna, and it shouldn't have because they are experts. It's not only that, people. I mean, it was so many factors besides what Detective Suarez and Detective Williams said. But whatever, they're just grasping at straws. So, state did not list either of these witnesses as experts and did not qualify them as experts in court. Defense counsel objected multiple times and requested Richardson trial hearing. So I guess they were in court. Richardson trial objection. This is not a Richardson hearing. Objection. This is wow. Okay. These defense lawyers are something else. Those objections were overruled, of course, because the judge probably determined that what y'all saying didn't make sense. Anyway, so I guess they get those objections were overruled, and then they stated a case, Gorilla versus State, blah blah blah, all those stuff. Holding the trial court should have held a Richardson trial and failure to do so was not harmless error where State failed to disclose that its lead investigator would testify as an expert. Okay. So I guess maybe they found maybe a loophole just because they didn't qualify them as expert. That's probably a loop. That's their loophole that they're using to get a new trial, wasting people time. Uh, since it's a motion, I'm guessing they're supposed to grant it. I really hope they don't grant this because this, even though she has a right to request a new trial, but you're gonna waste people time, waste the family time. The family already been going through this with living without their daughter and sister and aunt and different things. Now you're gonna put them again because you're being selfish. It's so many things, so many other things that has determined that this girl is guilty, taking that Kayla Hodgson's life. Come on. And then they stated in another case. Okay, they said another case. Okay, next one. The trial court erred in permitting testimony about CODIS hit received by the BSO crime lab. So that I know CODIS is that system. That's I believe is nationwide. I'm not sure if it's international, but that's a system where they put people's DNA in for different things, and sometimes they put if they find somebody is probably a suspect in some type of crime. Sometimes they could just put their DNA into the system, and it may hit on a cold case or something like that. Or in some aspects, when they have arrested somebody in certain aspects, they can take the person's DNA, and sometimes that's how they get certain hits on certain cases. That's how I understand it. So they said that the trial court erred in not permitting testimony about CODIS hits received by BSO Crime Lab. The court incorrectly ruled that defense opened the door when asking why additional items were not sent for DNA testing. These questions were regarding actions taken prior to receiving any CODIS alerts, yet the court ruled that this permitted the state to discuss CODIS. So, so this why I'm guessing they didn't want testimony about the CODIS hit that BSO received. So that wasn't, I guess it was not appropriate. That's what I'm gathering. Maybe if you see it someplace, if you see it in another light, that's what I'm gathering. Okay, this is another one. It says the trial court erred in allowing testimony that the police had not been able to get into Miss Thompson's cell phone. Okay, did she open the phone for them? Defense objected because the clear inference being made was that Ms. Thompson did not disclose her passcode. Defense argued this violates defendant's. Oh my God, these people can't be serious. Okay, so yeah, she opened her phone because she know what she was doing. Yeah, she know what they would have found. She know how she was stalking that girl. That's why she didn't want to open her phone. Because if she was so innocent, she didn't do anything. Why not open? Here, somebody. If I didn't do anything, I'm gonna give you my passcode. Look at my phone, whatever because I know I didn't do anything. She didn't because that violates her Fifth Amendment rights. No, she's guilty. That's why. She had some stuff in there that was incriminating. She didn't want them to see it. That's why she didn't open her passcode. So wow, that is that is crazy. Of course they're gonna allow that testimony because that showed that she had something to hide. I mean, if you're innocent, you have nothing to hide. There's nothing for you to hide. So that say so defense argued this violence violates defendant's Fifth Amendment right against self-incrimination, since past codes are testimonial. Yeah, it's self-incrimination, but if I'm innocent, I didn't do anything, I'm just going to give you my passcode. But she knows she couldn't do that because she know what she did. Anyway, so they give all these cases, whatever. Being forced to produce a password is testimonial and violates the Fifth Amendment privilege against compel several, whatever. Anyway, the trial court erred in permitting character evidence during the cross-examination of Miss Thompson. The state was permitted to ask Miss Thompson questions about drinking while she was approximately 2 to 4 weeks pregnant. Why is you drink? Yeah, because that shows the type of person she is. If you know you are pregnant and you such a caring and loving person, you're carrying life, new life in your womb. Why are you drinking? Because you know that can affect you. It can have a negative adverse effect on your baby, on the baby that's growing inside of you. But yet you're drinking. Yes. So now I guess, it was upset that they brought up, they brought up that testimony, or they asked the questions about that. This only showed the jury that Miss Thompson was irresponsible person. Yeah, that could show a lot. Well, somebody listening to that testimony that she was drinking while she was 2 to 4 weeks pregnant can take it different ways. Some people may see that she's irresponsible. Some people may see that she doesn't care about life. She doesn't care about life. So everybody can see that in a different light. So, was an irresponsible person and was not relevant to any issue at trial. The defense made a timely objection that this was irrelevant and impermissible character evidence. This court overruled defense. Of course, because y'all just wasting time, y'all just grasping. Oh my goodness. So that's the defense that they gave her? Wow, interesting. The court trial erred in allowing testimony about prior bad acts that had been subject of any Williams rule hearings. I guess we have to look up I'll just put up Williams rule. What is Williams rule hearing? So somewhere I put it up there. It says a Williams rule hearing is a legal proceeding in Florida where a judge decides whether to admit evidence of a defendant's past crimes in a current trial. So I don't even know why they bring that up, because it says the Williams rules, the judge decides whether it's is permissible, if they can bring up the person's past acts. That's why you better be careful what you do in your past. It could come back to haunt you. But anyway, so it's the judge is up to the judge's discretion. So the judge decided, which was Judge Siegel, decided that, hey, maybe, yeah, this can of course it's not going to help the defense if she was doing stuff. If she was such a good little girl, she wasn't doing anything, no, it's not going to be a problem. But she was doing bad stuff, so that's why they went back. They were able to bring up her past because she was doing stuff in her past. So let's see what she did. So the trial court erred in allowing testimony about prior bad acts that had been subject Williams rule. At the cross examination of Miss Thompson, that's why y'all is one who let her go on the stand. See, this is she went on the stand. Y'all allowed her to go on the stand when they questioned her about stuff that she did in her past. Had she not gone on the stand, where would they would not have been able, they could have presented it, but she went on the stand because I don't know what y'all think y'all was doing, and they questioned her about it, and obviously it didn't go well. So, because you see that they try to use that as grounds for a new trial, whatever. So it said that a cross-examination of Miss Thompson, this court allowed the state to question Miss Thompson about an unrelated violent altercation between Miss Thompson and her boyfriend 4 months prior to the date of incident. The boyfriend was not a party to this case, and this constituted improper evidence of prior bad acts where the prejudice outweighed any potential probative value. So, well, you could say that he's not related, but he's kind of is, because that's the reason. That's the reason why she took this girl's life, because of this man. Because Kayla was talking to, well, her man However it is, her man was dealing with Kayla. That's why. So yeah, he was not saying he's not, yeah, he's not a party to this case, but he was a factor why this case is even here. He was a factor because he was messing with both of these ladies, and that's what we know. Because we don't know how much other people that he was messing with, y'all. We just don't know. And then, of course, the state's going to bring that to show you how violent this lady is for this guy. She's just violent about this guy. Anything dealing about this boyfriend, she just lose all self-control. She don't know what's going on. So, and then it says the trial court erred in overruling defense objection to shifting the burden during the state closing arguments. At closing, the state argued that the jury was not able to see photos of Miss Thompson's injuries because she fled and she didn't make herself available. Yeah, she didn't call the police. She didn't call the police. She didn't go and say, hey, I got into this altercation with this girl. I went to talk to her, even though it was 4 a.m. because that was the best time for me. No. She fled. She went back to New York. So, whatever. The defense has no burden of proof, and this improperly shifted the burden by insinuating the defense should have brought in the photos. Of course, the defense should have brought in the photos. So even in this motion for them to get a new trial for her, you're just showing you how, in my opinion, this defense did not do a very good job for this girl. And now these are the same people that gonna represent you again, but hopefully not. Cause girl, you're just gonna be screwed. You're just gonna be wasting money. Because most of the time, sometimes when the defense motions for a new trial, not all the time they're the same defense lawyers that do it again if it is granted. So, since they didn't do their job and the state called them out about it, now they want to get mad. The defense want to get upset. This is what I'm gathering. Because she was like, Kayla hit up with the hookah, this hookah, and then of course it broke. And then with that same hookah that she hit her with, the second injury that she took one of the glasses and scratched her on her stomach, even though she was like, I think she was like 2 months pregnant at the time. So why would she immediately go to your stomach? Anyway, child. So since the defense didn't do their job and the state called them out, now they mad because why y'all didn't get, if she was injured so bad, she took the pictures. Why y'all didn't present the pictures? This is what happened. This is what, this is why this altercation came about. This is why she had to take the life of this girl because, she was in fear that she was going to lose her child. Y'all even presented that. This is what I'm gathering. I don't know if that's what it is. This is what I'm gathering. Now, they use that as a grounds to get a new child. These people are something else. And then you guys should have brought the photo. Y'all should have presented it. Y'all should have put it into evidence. That most likely probably would have helped her. Probably not. But anyway, but at least that would show that y'all were doing something. You ain't presented nothing. What did these people present? What did they just was sitting there objecting because that's what they looked like they was doing, objecting because they had no evidence. The state had an overwhelming amount of evidence. That's why they got the verdict that they got because they came with it. It didn't look like the defense came with nothing, barely anything. So the verdict is contrary to law or weight of evidence. Whatever. So wherefore the defendant respectfully requests this honor court grants this motion for a new trial. Oh Lord, I really hope. So they e-filed this today. I'm gonna see if they're gonna grant this foolishness. This is a bunch of foolishness. This is straight foolishness. But anyway, that's all I have to say. Thank you for watching, and I'll see you in another video. Bye.